All right, now, Scott, we're going to kind of go over your repo scenario here. This is going to be some cool stuff. I'm super excited about this. I think you guys are all going to learn something. And if not, prove it to me that you didn't previously know it. So first of all, we've got Scott here. So let's kind of enlarge this. All right. It's got a customer getting sued for a repo. And in the lawsuit, they are adding $11,000 for a NOL. Is this a net operating loss? What does NOL mean? What are they adding in here? What is this? He bought a 2018 Chevy Silverado in 2018 for $44,000, and the total finance charges were $11,000 on the finance contract. This seems completely outrageous. Scott, what's outrageous is fractional reserve banking, but we'll save that for an entirely different conversation. All right. They sold the car for $20,000, which seems a lot less than it is worth. They're suing him in Florida. Any ideas? Okay, so we've got that, and then we've got this complaint here. So actually, I believe one of the commenters said that NOL is potentially attorney's fees. I think I saw that. So I don't know exactly. So first, we'll take this. I don't know exactly what they would be putting in here as an NOL. Has anybody seen that term on repossession deficiency statements before? Matt Leestrom?
Notice of lien?
Matt is kind of like, I don't know what's going on with Matt. He's like giving me thumbs up. I'm like asking him a question, and he's giving me a thumbs up. But without
I've seen that on the stuff before. Yeah, that's just a common terminology. Notice
do we know what
accounting thing.
Do we know what it means?
I'm not sure I have a legal definition of it, but
so the question
seen it.
The question is, does it mean net operating loss? Why would
right, net operating loss.
It means notice of lien.
Because I can't imagine, because you wouldn't put a net operating loss as a line item. What would happen is your total would be like, your balance due minus, and then if it's a negative.
I understand now.
You know what I mean? So that's what we're trying to figure out what that is. But
I thought it was just notice of loss. Notice of net.
They spent $11,000.
I would have thought, but I'm really not sure.
Spent $11,000.
You're going to charge $11,000 for a notice?
Yeah, they can work with the government with that kind of levels of inefficiency, huh? Man. Okay, so we've got this here. So Scott Sheff, sorry to disappoint. I don't have the exact answer to this, but I am going to kind of rabbit hole trail into something kind of exciting. So a couple of things. So number one, if we do look at guide number 64, we have a lot of cool stuff on repossessions, which ties to the UCC. All right. But like any good timeshare commercial, but wait, there's more. So what I want to do is take us to the NCLC repossessions book, okay, which again, you guys all have access to this. If I can get my thing to open up over here. Okie dokie. All right, so, no, wrong link. There we go. All right, so this NCLC book, there is a book. If you guys go to your library, there is a repossessions book. Oh, we lost Scott. He's coming back here. All right, so there is a repossessions book. If you click on the repossessions book, it'll open up, sort of, with my super fast internet, by the way. Okay, and so here's your book. And so if we look at so you've got the chapters, which we're not really concerned about for the purpose of Stephen enlightening you in this segment, but we're going to look at the appendices here. By the way, how many people knew that the plural of appendix was not appendixes? I knew that because I had those Catholic schools wrap me over the wrist with rulers when I was going to school, but appendices, that is the plural, like cactus is cacti. I digress, guys. I'm so sorry. Okay, let's focus again here. So let's go to, we have our sample repossession, discovery, and request for admissions. Down here, sample, so where the hell was it? Sample, here we go, pleadings and discovery. Here we go, pleadings and discovery, companion material. Here we go, pleadings and discovery. Complaints, a complaint is kind of a legal word for the lawsuit document, okay? So we're going to go to complaints. Okay, and let's see here. Complaints. Come on, open up. Where the hell is it not opening up? Okay, I don't know. Let's see. Default files, New York complaint. I had it open on this one. Don't know. Why? Let's see. Let me click on this. Maybe I'm clicking on the wrong one. It's right down here somewhere. Anyway, point being, pleadings and discovery. Oh, here we go. Yeah, initial pleadings, complaints. Don't know why the hell it is not opening up. Anyway, I've got it opened up over here. So here is a complaint. I'll have to find, well, actually, I've got the link right in here, don't I? If we go back to this here. So here we go. This is the link to it. Okay, so I found this morning. I can't find it now, but that's okay. So here we go. Here is a sample in the NCLC, a sample file of a unlawful repossession lawsuit. Okay, which is kind of cool. You guys can follow the link and go here. And, we're not going to, bore you with all the facts and everything like that. What we're going to do is go down, facts. Okay, there was a repossession. Big deal. Okay, we're going to go down to the causes of action down here. Okay, so this is in New York. Okay, so the first claim or cause of action, Equal Credit Opportunity Act. Okay, so I want to kind of, I know, Scott, you're all about the repos and everything, and there's a lot of people that are all about the repos, and the whole pre-lit mindset is you got to find what's wrong, but then you got to figure out how to pitch it to the attorney, right? So Equal Credit Opportunity Act, was there any sort of discrimination on any part of the credit transaction? So the takeaway here is how you can tie all these statutes together, but this isn't even the cherry on top I was going to share with you guys, but we'll get to it. So if we're really trying to figure out how to put the squeeze on these repossession credit cases, again, we're not practicing law. We don't want to do that, but we want to understand the end game. How do you maybe ask for things and kind of see if there's a fact pattern that could emerge that supports these things. So let's see. The dealership regularly extends. Can you guys see this, by the way? Let me enlarge it. Okay, here we go. The dealership regularly extends, renews, or continues credit. In an instant action, a dealership is a subsequent assignee of AmeriCredit who regularly extends credit. Let's see. As a creditor, dealership is responsible for providing consumers, such as plaintiff, its reasons for taking adverse actions. Adverse action is defined under the Equal Credit Opportunity Act, revocation of credit, as well as a change in the terms of existing credit arrangement. By unilaterally repossessing the vehicle rather than allowing Mr. Consumer to continue making payments under the loan, the dealership revoked Mr. Consumer's credit and or made a material change in the terms of an existing credit arrangement. Okay, so again, I can get past the fact portion because I don't, you guys can read this, but I want you guys to see the causes of action so you can see if the facts support it, how you can tie these things together. Okay, as such, the dealership needed to provide a statement of the reasons for its adverse action against her or its failure to do so violated the statute. Okay, so they're alleging that they violated the Equal Credit Opportunity Act in a violation that does have a consumer private cause of action, right? So that's kind of nugget number one. Okay, this was the cherry on top where I told you that you guys were all going to learn something here, and if not, prove it to me that you didn't learn it on this first. Okay. Second claim for relief, Fair Debt Collection Practices Act. Okay. Repo Joe's a mean mofo, and he's also a debt collector under the FDCPA. Did you guys know that? Well, you're about to find that out. Okay. So plaintiff, okay. So here we go. Per the FDCPA 1692 F6, a debt collector may not use unfair or unconscionable means to collect or attempt any debt. Okay, let's go to that real quick. F6. Okay, so I'm going to keep that one because we're going to go there in a second. All right, let's go to F. Okay, so FDCPA, we all know this. This is cookie cutter right here. Unfair practices, F6. Taking or threatening to take any non-judicial action to affect disposition or disablement of property. Non-judicial repossession, which is what you do. The tow truck driver, Repo Joe, that dude comes out with the hook, hooks it on, and walks away, drives away with it, okay? So if they take or threaten to take any non-judicial action to repo your property, if there is no present right to possession of the property claimed as collateral, Okay, so if they say that they don't have any right to it, it's an unfair debt collection practice. If there is no present intention to take possession of the property, okay, but they threat. So if they're like, we're going to repo your shit, but then they actually don't want to, that's actually a violation. And then if the property is exempt by law. Okay. So Repo Joe comes out there, and if you can argue there is no present right to possession of the property of a security interest, it's an unfair practice under the FDCPA. However, Stephen, that still doesn't mean that AmeriCredit, which is not a third-party debt collector, falls under in here, because this covers just third parties, right? But that's where you're going to learn something even more amazing. So let's take a look at that. So this is one half of the avocado. The other half of the avocado that makes the perfect little couple is 1692. I think they misquoted it. It should be A6. Okay, so any person who uses any instrumentality of interstate commerce or the mails in any business, the principal purpose of which is the enforcement of a security interest. Okay, so if you are out there enforcing a security interest, this is actually part of the debt collector. Again, they forgot to put the A in there, so let's go to this here. Okay, so 1692A, 6, the term debt collector means any person who, look at this, for the purposes of section 1692F6. 1692F6, look at that beauty right there. For the purposes of, if you are the tow truck driver trying to hook up on that beauty, for the purposes of repossession, basically type things, such term also includes any person who uses any instrumentality of interstate commerce or the mails in any business. The principal purpose is to enforce a security interest. Okay, so you got somebody who's trying to enforce a security interest. They're not a third-party debt collector. They are still a debt collector. So AmeriCredit, which is one of the subprime lenders, is in fact being argued to be a debt collector here. Okay, so point there being, if you've got repossessions, FDCPA attaches to that. How amazing is that, huh? Did you guys learn something here? Go ahead, make me feel good. Lie to me and say you did. Yeah.
What were the exceptions?
Yeah, can you go back to those exceptions, the last screen, Steve?
Yeah.
Well, okay. I mean, that's fine. That's not. I mean, yeah. So the term does not include. I mean, this has nothing to do with anything that is relevant here. I mean, basically, an officer of a creditor while using the name of the creditor. So again, this could confuse people because, I mean, if AmeriCredit is collecting a debt under AmeriCredit's name, if it were not this exemption, like that's why we say Chase Bank is not a debt collector, because they collect debts in their own name. You know what I mean? Like if Chase Bank were to go out there and say, well, this is a Guido collection agency on behalf of Chase, now they're using a third-party name, so then they become a third-party debt collector. But, if you're collecting a debt in your own name, except for the language of law that says otherwise that we just read, but typically a creditor is not a debt collector. Any person while acting as a debt collector for another person, both of whom are related by common ownership or affiliated by corporate control, if the person acting as a debt collector does so only for persons to whom it is related or affiliated, and the principal business of such is not the collection of debts. Okay, so I guess my last example doesn't fully apply. So if you've got Chase Bank and they own Guido Debt Collector, and Guido Debt Collector is only applying debts, collecting debts for Chase, whoopsie, what the hell happened here? Then that's going to be excluded. Okay. Any officer of the United States, okay, so the U.S. government, any person while serving or attempting to serve legal process. So, I mean, if you're serving somebody a lawsuit, you're not a debt collector. Nonprofit organization, bona fide consumer credit counseling. Okay, there you go. Any person collecting a debt owed or due, asserted to be owed due to another, to the extent that such activity, one, is incidental to a bona fide fiduciary obligation. So if you're a power of attorney or a fiduciary in general, and you're just trying to collect a debt, kind of in your general fiduciary power of attorney duties, you're not a debt collector. Or concerns a debt which was originated by such person. So, I mean, if you're collecting, again, kind of on your own debt, concerns a debt which was not in default at the time it was obtained by such person. Okay, so again, that's kind of important because, we see this a lot in the mortgage world. If a mortgage is in default when it's transferred to another mortgage servicer, then typically they are a debt collector at that point because they assumed a delinquent mortgage. But if you transfer a debt with respect to this that's not delinquent, and concerns a debt obtained by such a person as a secured party in a commercial transaction involving the creditor. Okay. So there you go. I mean, these exceptions have nothing to do with what we're talking about. These have been here for eons. But the point there being, for the purpose of the Repo Joe unfair clause, such term includes any person who uses any instrumentality. Okay, so back to this. So if you are trying to figure out your repossession cases, this right here, and this should be 1692A6, just for a point of clarification, 1692A6, okay? Okay, so as such, a debt collector violates this section of the FDCPA when it, and then, this is what it says right here, right? Takes any non-judicial action to effect disposition or disablement of property if there is no present right to possession. Now this is where they're going to have to, survive summary judgment or whatever if there is no present right to possession of the property. Okay. Through an enforceable security interest, right? So, I mean, we want to, make sure, again, we're not practicing law over here, but we can at least, what do we want to ask for? Well, I mean, did they have a security interest? Okay. And then if they had the security interest, was it proper? Did they have the proper right to claim this as collateral? If they met both of these parts, then, this is not obviously a deal, right? I mean, you can properly repossess a vehicle and you're not a debt collector. But if you improperly repossess it, then that is a deceptive FDCPA practice. Does that kind of make sense, guys? Yes, no?
Yep.
So you can do your business properly and you're cool, but if you're taking people's secured property and it's not proper, now you are under the unfair, deceptive property there, debt collection. Okay, so in repossessing Mr. Customer's vehicle, defendant used an instrumentality. So they did engage in interstate commerce. Okay, however, since so I guess this lady was not in default, I suppose. So since Miss Customer was not in default on her loan, the defendant was not entitled to effect dispossession or disablement of the property. Okay, so obviously, how the hell are you going to repossess a vehicle that's not in default? So that's obviously cut and dry fact pattern. So so there you go. So that's that. So just to kind of recap, we've got causes of action against the Equal Credit Opportunity Act. We have causes of action against the FDCPA. Okay, so this is where the UCC comes in. It's important to understand that the UCC is what's called a uniform code, which is not a law. Okay, it's important to understand that. What happens is sometimes you have industries that get together and they are regulated, however, or maybe not regulated, or regulated under state laws, or usually not regulated, but they kind of see that things are going to be getting regulated and they want to have a seat at the table. So like their trade associations or whatever may hire some fancy attorneys and they draft a uniform code. This happens to be the Uniform Commercial Code, but they draft what they call a uniform code. This is done in other industries. The debt settlement industry had a similar thing drafted. And then they try to get it adopted by states, okay, essentially. So the UCC itself, is important to understand, is not a law, okay? It is a framework. It is a uniform code that was drafted by the commercial credit industry. And then they lobbied and had it passed by all 50 states, okay? So, technically speaking, as those state laws get amended every legislative session, the UCC, they try to not butcher it, but the UCC version of each state law is a little different in each state, honestly, right? So it started as a uniform code, got passed by all states, but then obviously, the legislatures, your elected representatives, if there's something that needs to be changed, they can. So this is the New York Uniform Commercial Code, okay? So the New York's version of the UCC. So again, you're not going to sue under the UCC as a cause of action. Important, that's your takeaway. you have to find under your state, like in Texas, it's part of the Business and Commerce Code. Okay. All right. So the sections generally kind of stay kind of where they are. But so let's see, 9-611. So let's kind of take a look. 9-611. Okay, so we're going to look at the UCC. I'm not going to pull up the New York one, but because again, it all started as this uniform law. So 9-611, notice before disposition. So they're saying they didn't send them a notice. Okay, that's kind of one claim. 9-612. Let's go to 9-612. Timeliness notification. That notification needs to be sent within a certain time period. 9-614. All right. Contents of the form. So the form did not contain certain things that it's supposed to contain. 9-616. Okay, let's go to that. Explanation of calculation of surplus or deficiency. So allegedly they did not provide an explanation of the deficiency. Okay, so these are kind of under the New York UCC, the violations. And so pursuant to, and then 9-625, this is where you can have your private remedy. Okay, 9-625. 25,
Or 625A.
Remedies for secured, there's now Scott's getting all excited. Remedies for secured parties' failure to comply with article. Okay, so, so basically this is kind of like the equivalent of in the FCRA, your 1681N and your 1681O, which are your willful and negligent noncompliance provisions. Those are the provisions in the FCRA that spell out specifically, hey, Mr. Consumer, you have a private right of action under willful or negligent noncompliance. This is part of the UCC that spells out, okay, Mr. Debtor, you have remedies for certain violations. Okay, does that make sense, guys? This is where your right to pursue remedies comes in. Okay. All right. So that's going to be your UCC. I'm not really going to go over these because this is New York specific, but it's important to understand that each state is going to have state law, deceptive trade practices type things, whatever they call them. So New York business law, whatever this is, they've got a cause of action there, and then some other New York general business law. Okay. All right. And so sixth claim, okay, conversion, which is some legal thing above my pay grade. Seventh claim of fraud. Oh, well, there you go. So let's take a look. How they do the fraud. The dealership fraudulent. Oh, here you go. This is beautiful, huh? Buy my car, and then we're going to repossess it when you're not delinquent, right? That's basically what happens. So the dealership fraudulently induced plaintiff to enter into a retail installment contract for the purchase of the vehicle, which is for a different model than the one verbally. Okay, well, shit. So a little bait and switch, I guess so. Okay. Plaintiff justifiably relied on dealership's misrepresentation. Okay, let's see here. So looks like some misleading. Had they been truthful about the sales terms of the retail installment contract, they would not have made. Okay, so there you go. You got some fraud. Ooh, breach of contract. Okay. Again, we're not here lawyers pretending to lawyer up, but repossessions are those really big pain in the asses, right? So I think if we, if we can see the end result here of your work, right, as a pre-lit, doing things, actually sending out real letters, asking for real questions. Again, you may not get any of these answers, and we don't know, but at least, now you can go to the, you can take your client file and did you ask for the contract? Okay. If they didn't send it to you, then we don't know if there's a breach of contract. Maybe they're holding it, but they didn't send it, right? But in this case, breach of contract. Okay. Blah, 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 so forth. Okay. So there we go. That's kind of the end of it. All right. So let's open this up for a little conversation here, guys. So we've got repo, we've got equal credit opportunity violations. We've got, let's see, Scott Sheff. Go ahead, Scott. Yes, sir. Talk to us, buddy.
All right. So yeah, I don't know if you got it. I sent you a big email kind of with something similar to this because I have a client who basically I had a sample like lawsuit that I had in there, and basically that's section 625A that is for the when they don't send the notice and they don't send the calculation of deficiency, the punishment for that is in that section 925A.
I think
right
now. Let's see, was this?
You were the last one you were at, where you were just like, this is the punishment.
Let's see here.
Yeah, okay. It was the 610, 611, 616, 614. Those are where they all are. Those are the notice of for the notice of sale, the calculation of deficiency. So like if what I do is I send letters out.
Oh, here we go.
Hey, send me the notice of sale, send me the calculation of deficiency balance, send me the, the required notices basically they're supposed to send. So by law, they have 14, or I guess by, whatever, it's the state law or, Article 9, I guess. It's not a law, so I don't know. But under Article 9, those sections, basically the penalty is for, like, if you request a copy of it, a lot of times they don't send a copy of the notices that they were supposed to have sent, right?
Yeah.
Basically, a lot of times they don't send it. So and this woman's getting sued and she's like, I swear she never got a darn thing, nothing. So I'm telling her, trying to help her out. So that's one of the reasons why I'm trying to get to the bottom of it. So the punishment for not sending the notice, not doing the calculation, is that section 925A, which you were at. It was one of the last pages you showed.
Yeah. And this was what you had emailed. I think you're talking.
But can you pull that page? Yeah, can you pull that page up? The 925A.
Yeah, let me do that. Okay.
Because then what it says under 925A is that you can be restrained from collecting the deficiency and also the damages. And then the damages are 10% of the finance charge plus 10% of the purchase amount, and then there's something else that says, there it is. Damages for non-compliance. Subject is that the person is liable, cause or failure to comply with this article. The loss caused by failure to comply, including loss resulted from the debtor's inability to attain alternative financing. So if the person goes and they can't get a car now because of that, right? If they didn't send, is that saying if they didn't send the notices, they sold your car, they didn't notify you, your damages for non-compliance of that is the loss for failure to comply, loss caused by, basically, you can't get a car now, right? So you can show you can't get a car, they're liable for that. And then there's a part that says that can be restrained. There it is, restrained, you have it highlighted. A court may order or restrain collection, enforcement, or disposition of collateral on appropriate terms and conditions. So I didn't really get, on appropriate terms and conditions, but basically from what I'm seeing is that that's saying you can stop them if they didn't send the notice, right? If they just didn't send that notice, then they cannot collect basically the balance that they're claiming that the debtor owes. Basically, and where is the part about the 10% of the finance charge? Oh, there it is. It's under C2, same page, C2. If the collateral consumer goods, the person debtor, second at the time of this year, failed to comply with the part, may recover for that failure in any of that amount, not less than the credit service charge. Oh, I'm sorry. It's the entire credit. Yeah, that's what I said. Entire credit service charge plus 10% of the principal amount of the obligation. So is that credit service charge when you look at the resale installment sale contract where it says amount to be financed, $12,000? Is that what that is?
I think it's your interest, I think is what they're saying. So whatever your interest would be.
Right. So yeah, that's the amount you'll pay, like basically your total interest paid.
Yeah.
That's usually a lot plus the principal amount. So if that's like $11,000, let's say it's $10,000, right? And then the purchase price is $30,000. So that'd be 10% of 30,000, 3,000 plus 10,000. That's $13,000. Plus, let's say you go and try to get a car, send them off to a dealership to try to get a car and get them denied and bring that as well for loss there. You're looking at damages at a minimum of 13,000 plus more, if you can easily just, so I'm looking at this and I'm saying people are chasing these $1,000 violations for a letter and the CC violations and the E8 violations, which is great and fine. I'm not saying anything wrong with it. But why not go after this? I mean, just for not sending a notice, if you can get the whole finance charge and 10% of the principal, that's a lot more in damages than $1,000. So why are people all over this?
I agree. No, I do agree, and I think that's why this is a good segment that we're having, because you guys can clearly see there's a lot of other ways. Well, you can see the end result of asking the right questions, right? So did you have a security interest? Can you prove to me you had the security interest? If not, then FDCPA could attach. Did you send these notices? If not, then boom, here you go. The whole thing is unlawful. So you're exactly right there, Scott. And it looks like Robert Sigmund had posted up that NOL stands for notice of lien. So, I mean, I guess whatever that means, I guess they're saying that $11,000 for the whole repossession freaking, I mean, is the notice of lien the whole repossession activity? I'm going to assume that's probably what that is. So, any other questions or comments, conversation here on this repossession segment that we're doing here?
So what can we do? I mean, what do we do if we have a consumer that is getting...
Scott? We lost you. Scott? Let's see, Scott. We lost Scott. I think that was the government going in.
Come back to the microphone.
I think that's the government going in there. They're not happy with Scott at this point. He's figuring out.
Well, he comes back. Scott, if you get back, just interrupt me. But I've used that before too, and I've successfully used that. You can't collect a deficiency balance if you can't show you provided those notices, and that some states has my understanding, and this is my understanding. I don't know where this knowledge comes from, except that it's in my head. Is that some states have specific verbiage, but I think that's pretty universal in every state. You can't collect you can't show those notices and the consumer received it. You're not entitled to any deficiency balance, period.
Exactly.
You know, Brian Ponder's got a good letter to request all that documentation with. I've used it several times and then forwarded the results to attorneys, and they like it.
Good. Yeah, I mean, that's what it's all about. And the point, you'd see where the end result is, which is the attorney letter or the attorney lawsuit, right? You know, and then you kind of reverse back into it. Same thing that we talk about with the Metro 2 itself. I mean, I've got a sample of, a lawsuit where you take all the data, you throw it in for FCRA claims. So if you know where you're going, then you know how to ask the right questions to get there, right? You know, and we've got a pretty good group here. I mean, we all talk to different attorneys and stuff, and, you know, they all will tell you if the CROs actually hand them files where the paper trail reflected the story that the CRO tells the lawyer, then they would love the cases. The problem is the CRO goes to the lawyer and they're like, oh, well, but blah, 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 blah. And then they give them the dispute letters, and the dispute letters are total garbage. They have nothing to do with actually what the fact pattern is. And the attorneys are like, well, why didn't you actually put that in the dispute letter? Well, we know why, because, people are trying.
Or even more prevalent, the attorney doesn't understand the fact pattern.
That's
educate them on what the fact pattern is, hopefully.
There you go. That's part of it too, right? But for the ones that do understand it, a lot of times they just they're like, well, why didn't you put what you just told me in a dispute 6 months ago, right? But, well, because I was just picking a letter for the software. Well, you see the problem. The problem is with you, Mr. CRO, not with me, Mr. Lawyer, in that scenario, right? So,
hey, if you had some good software that had some good letters to pick from, hey, that could be helpful.
Yeah, you know anybody?
Little shameless plug from that. Which, by the way, don't you have? You got some updates to your credit admiral. Don't you have like some dollar trial or something going on? Let's give you a chance to plug.
Yeah. We offer every month. We offer a dollar trial to the end of the month. So we try and push that in the beginning of the month because you can pay $1 for the whole month. If you do it on the very end of the month, you get $1 for like the last 3 days. It's not so good. But if you do it at the beginning of the month, you get the entire month for $1. So it's $1 to the end of the month. We do all our billing on a monthly basis. So if you sign up, you can choose to bill it on the 1st, the 3rd, or the 5th, whatever day. But we do it always for the month before for that month. It's just a month by month, but we do it at the beginning of the month. So the $1 to the end of the month.
Can you answer me this, Matt, while we're on the topic? Can you break down multiple fact disputes on one account where you can list 20 errors in a account? Generate that 13-page letter that they love?
Yeah, absolutely. So we set it up so you can select each base segment field of the Metro 2 format, and you can select which one of those base segment fields are wrong, and you can select as many of those as you want that are wrong. And we have it in there that you can, because each base segment field is a code, and it can either be one of three things. You can either select that it's wrong, it's missing, it's not there, or it's not consistent across all three bureaus. And you can select as many of those base segment fields as you want and tag this, this one, the credit limit is wrong. The balance date open is missing. The date of first delinquency is not there, is missing. The late payment history, the payment status is wrong on all three, is different from all three bureaus.
Like, for instance, the payment history, this month is missing, this month is missing, this month is missing, this month is missing.
No, we don't have it specific so you can say which actual month is missing. We just said that field is wrong. The payment, the credit limit is wrong. The balance owing is wrong. The payment history is wrong. It doesn't get granular to say which months it's wrong. It just says it's wrong. But that should be enough to clue them to check that history in those months. Or it's really the only thing that goes month by month. I want to designate
the specifics of how many individual errors that they're supposed to be investigating, rather than the payment history.
Well, yeah, and
here's a month. Investigate each and every one of these, because I'm going to sue you for every one if you don't fix it.
Yeah, that's on my agenda to try and get answered by some of these experts, like who are from the old credit bureau behind the scenes. Is it true that you can only put into the system? Now, we know when they enter those disputes, they can't. You select 7 things for dispute. They can't dispute all 7. They've got to pick and choose what it is. And so they probably are going to select this button that says verify the whole account. So even though we wrote the letter and we were very specific, it's probably going to get turned into verify the whole account.
I just want to, when I show the judge.
I had an attorney say you got to copy the furnisher. The bureau dispute, that's why you got to copy the furnisher with the bureau dispute so that they can't wiggle out of it. Because if the furnisher gets it, if you dispute it as this date of last payment was this, and then the guy at the bureau clicks not mine, and the furnisher gets not mine, they're not liable for not doing your original dispute that you were specifically disputing it for. So that's why Aaron, actually, that attorney Aaron said you got to copy the furnisher on that dispute so they can't wiggle out of it for that.
I have heard otherwise, that theoretically the bureau is supposed to supply that information to the furniture, and if they don't, that's their deficiency. You just get a statement from the furnisher, they never got the dispute.
So what Scott's,
go back and sue the bureau.
So what Scott's saying is, if you want to try to, if you send it to the CRA, yes, if the CRA doesn't forward it to the furnisher, the CRA would be liable. But then the furnisher would sit back and say, well, we didn't get it, so you can't hold us liable. And that
Great. Give me a letter that says you didn't get it so I can use that against the bureau.
But then to the point of Scott, I would disagree. I mean, obviously that came from an attorney named Aaron that you mentioned, but I would still disagree, because then that would be a furnisher direct dispute, which they have no liability for. And so I still think it would be hard to hold a furnisher.
If you're just saying, hey, here's a copy of the dispute we sent to the CRA, this is not a dispute to you. It's just the CRA may give you the wrong reason that we sent to them. So this is the reason that we sent to the bureau.
Yeah, they're supposed to give you the reason and the full document.
Yeah,
right, but the bureaus code things wrong all the time.
Exactly. That's good for us.
But the furnishers don't have to be liable for not disputing it, because they can reply to whatever the bureaus give them, which isn't necessarily what you put in your letter to the bureau.
So what do you care who's liable, the bureau or the furnisher? Doesn't matter, as long as somebody is.
Sue them all and let sue them all.
Depends on what you're doing.
I'm going to chime in there too. I think I was saying this a long time ago, and I do less disputes, so I will ask some of the guys here who do more disputes than I do. I had seen many times where through eOscar, we know they can now put an attachment. And I believe that many times what they're simply doing is entering a dispute, but attaching the letter that we've sent. And I know this because we'll do a dispute on ABC Credit Union, and the credit union sends back, you disputed this with the bureau, and they have the entire dispute letter that was sent in. Not just their particular item, but the entire letter what was mailed. And what I haven't been able to figure out is if that's really going on, that often those letters are simply being attached and the creditor is seeing the entire dispute letter. Then how is there not a HIPAA violation if that letter contained, I'm disputing this cancer treatment, whatever, because there's protected health information in there, and why in that information is now being disclosed to the credit union because they're getting the whole letter. That letter wasn't intended for them, only that particular portion was. And why is that someone not pursuing a class action for using eOscar in that way to put the whole letter in there and not the specific portion that applies to that creditor?
So HIPAA wouldn't cover anybody else except for who it covers. So it covers like the insured or the insurance companies or the medical providers. So if they throw a bunch of stuff in the garbage can and then I go dumpster diving in the garbage can and get your private stuff, they're liable.
It's different when you providing it to them. The credit bureaus are entrusted with that health information because they're supposed to pass it along to the collector. That's the process. But if they're negligent and don't handle their information properly and they send your health information to the credit union who was never supposed to see it, your intention was to give it to the credit bureau who would then give it to the collector. Now the credit bureau is negligent with HIPAA because they've taken your protected health information, which was in their custody because of the dispute process, and they provided it to an unauthorized party. That's the theory.
Yeah, well, but HIPAA doesn't attach to everybody who touches the information. It's only the originating parties, like the insurer, the insurance companies, or the patient. So if the information came from the hospital to the patient can go ahead and publish it in the New York Times if they want to, and that's okay.
Yeah, I follow you now. Okay, I understand. I got to tie that back to the original medical provider. All right, I follow you.
Yeah, unfortunately. But, knowing you, Matt Listro, with your way of basically creating facts that fit into, fictitious theories, I know you got the reverse HIPAA, which sounds amazing. You're going to have like the double reverse, somersault HIPAA. You're going to figure out how to make this thing work, aren't you? All right. So there we go. All right. Wasn't that exciting on the repossessions? I thought that was super exciting.
Great segment.
All right. That's why you guys stay in here, because I do seem to throw little nuggets every now and then. All right, so as we wrap up our